Acharya Lukesh ji, Mr. Marwa, Mr. Agarwal, Shri Pradeep Rai, other distinguished guests on the podium, my young friends, ladies and gentlemen. At the outset, thank you very much, the organizers, for inviting me to speak on a subject which I consider very important, and that is the Right to Information Act. All of you budding lawyers are aware of the background. The first Freedom of Information Act that was passed was in 1766 in Sweden. And by and large, this movement was led in the West. But the act in India was promulgated in 2005. We've had acts earlier. I think the state of Tamil Nadu was the first state that promulgated a Right to Information Act in 1997. We had a Freedom of Information Act in 2002, but that could not be implemented. And finally, in 2005, we have the Right to Information Act. Now, the Right to Information Act is very important, and it's very important because today, as Mr. Marwa mentioned, we are celebrating World Human Rights Day. I'm sure you're aware that the Universal Declaration of Human Rights of 1948 talks about the right to information as a universal right. And our Constitution, Article 19 and 21, they embody the right to information as a fundamental right. So I think this is an extremely important piece of legislation that the Parliament of India enacted, and it came into effect on the 12th of October 2005. And it's been 18 years since this act has been implemented. I'm not going to go into detail as to how the act is implemented, the various tiers in the act. The act itself provides for a public information officer, both at the state level and at the central level. But each government authority, a public authority as the Act defines it, has to register with the central government, with the commission in the center, the Central Information Commission, or the state information commissions in the various states. And as of now, the Central Information Commission, the last count that I saw was 2,298 public authorities are registered with the Central Information Commission. Now, why is it important? Because every act has to be implemented effectively. And in this 18 years, we've had an experience of how this act has been implemented. And more importantly, we have been guided by the judgments, very important judgments of the superior courts, the Honorable Supreme Court, and of course the Honorable High Courts all over the country. So they actually shape our decisions when RTI application comes on second appeal or as a complaint to the Central Information Commission or the State Information Commissions. So I think it's very important that a citizen is able to seek information from any government department, institution, or public authority. And in that sense, the Act itself treats a common citizen with the highest in the land equally. And that's extremely important. Now, what does the Act seek to achieve? The Act seeks to achieve a better informed citizenry. And it promotes transparency, accountability in the work of the government. Now, you may ask whether 18 years has this Act succeeded? And my answer to that is that depends on what prism you're looking at this issue through. The glass, as they say, is either half full or half empty, and it depends how you look at it. But I think most important, it is the job of each one of us, actually, as citizens, to ensure that the Act has been implemented effectively. In my almost 5 years in the Central Information Commission, I found that by and large, the Act is being implemented effectively. Of course, there are always cases where, as lawyers, and you're aware because you can argue both sides of an argument, you're aware of how the law can be circumvented also. But I think what is important is that we have an Act in the statute book, and we have a superior judiciary that is very much involved in ensuring that this Act is implemented. And the very fact that the Act has been amended only twice in the last 18 years itself shows how well thought of the provisions of the Act are. And you might feel that this entitles you to get any and every information from any department of the government. And that's perhaps correct. You are entitled to do that, but the Act itself provides for certain safeguards. Like Section 8(1) of the RTI Act provides for situations where exemptions can be given. For instance, Section 8(1)(a) talks about sovereignty, territorial integrity of the country, foreign relations, relation with a foreign country, economic security, etc., an exemption. 8(1)(b) talks about where information is specifically prohibited by a court. It cannot be a matter sub judice. Of course, having said that, you must be careful because a lot of the appellants and lawyers and, of course, the respondent, the public authorities plead that once a matter is in court, it is sub judice and information cannot be provided. That is an incorrect interpretation of the Act because 8(1)(b) specifically says only when the court prohibits parting with information that you can deny information. Of course, many a time you decide in the Commission whether information, if it's revealed at that stage, would it in any way prejudice the outcome of the case or jeopardize, actually not prejudice, the wrong word, jeopardize the case itself. For instance, 8(1)(h) provides for an exemption if the matter is under investigation or under inquiry. But every exemption has to be justified by the public authority. Merely quoting, for instance, the police, if it claims that a matter is under investigation and information cannot be revealed, and they say when the charge sheet is filed in court, at that time the defendant would get an opportunity to see all the documents. I think that would be an incorrect interpretation because the police will then have to justify how denying the information at this stage is going to affect the investigation. So these are some of the exemptions. Of course, the most important, in my opinion, and oft quoted, is 8(1)(j), which is privacy laws, the privacy information, right to information which impinges on privacy and your personal information. And the recent amendment to the Act makes it very clear because the original draft the original Act, talked about wherever there is larger public interest, it overrides the right to privacy, right to personal information of a public official. And there was one clause that was inserted separately, which, in my opinion, I found it very difficult to try and see how to implement it. It said that any information that can be given to the Parliament or to the state legislature should be revealed. Now, that's a very omnibus provision because, as you're aware, the Parliament is supreme and has the right, or the state legislature, to get any and every information. And by trying to implement that, basically you are overruling a large part of the exemptions already provided. So I think the recent amendment has got clarity. It has removed that the reference to Parliament and the state legislature, and it has limited the scope of that provision by basically ruling out larger public interest. Now, larger public interest also is a matter of interpretation. So each commissioner or each commission would then interpret larger public interest as to the way he or she feels that information should be revealed. That introduced some amount of subjectivity. Now what has happened is that has been clarified, so that has been removed. Also, I guess it was also due to the fact that this provision was used to try and harass officials by seeking personal information regarding their person. In fact, there were Supreme Court judgments, and the latest one, if I recall correctly, was the Subhash Chandra Agarwal judgment of 2019, which clearly defines what is personal information. So I think in the 18 years, this Act has had have been built upon by these judgments, these landmark judgments of the superior courts, and also the way the Commission itself has interpreted the Act. Now, before I conclude, I'd like to just also mention the challenges, the pitfalls that we faced in the Commission in implementing the Act. Now, the Act itself is extremely popular because, if I remember correctly, in 21-22, there were 14 lakh RTI applications filed. In the Central Information Commission, our pendency, when I took over as chief in November 2020, was 39,000. At the beginning of this financial year, on the 1st of April, it had dropped to 19,000. Now, that, of course, depends on the quorum of the commission, the number of commissioners you have, and how fast you're able to dispose of it. During COVID, we faced particularly challenging times, and we resorted to technology to try and resolve the problems that we confronted. We did, of course, we set up camp offices in our homes, but more importantly, we resorted to more video conferencing and even audio conferencing. In fact, the smartphone turned out to be very important because we were able to conduct hearings sitting at home or in office, even during the lockdown, as long as the appellant and the respondent were available. It's not the ideal way of doing it because you're not sure who's on the other side, but the fact is that we were able to dispose of a large number of cases. In fact, in July 2019, in July 2020, we disposed of more cases, this is during COVID, than in July 2019. So that shows that you need to adapt. But the challenge remains that in the rural areas, in areas we still don't have proper dissemination of information. So you have situations where a poor farmer is seeking information but does not know how to do so. And certainly had a challenge trying to file online, because now we have digitized everything, and which is a very good thing. We can file applications online, we can follow first appeals, second appeals online, and you can have an e-book of the case that especially the public authority, to facilitate disposal of cases. So I think these challenges need to be overcome, and I think where governments, our state governments and central governments are doing their bit is try and organize seminars, conferences, workshops, so that the people are made aware of what is essentially a fundamental right, and the right to information. And as you say, better informed citizenry leads to good governance. And I'm particularly happy that the present government lays a lot of emphasis on citizen-centric governance. And citizen-centric governance can only happen if there is a better informed citizenry. With these words, I'd like to thank the organizers for inviting me to share some of my thoughts on the RTI Act, which I'm sure all of you in your various capacities as citizens, as lawyers, will come across, and I would recommend that all of you read it. It's a very simple, even for a person with no legal background, I was able to grasp the nuances of the Act very soon. But thank you very much for inviting me, and all the very best.